Speeding fines, tickets. Is it possible to basically not get done? Well, first of all, I've got to say right up front at the top of this video is not about encouraging reckless driving or condoning speeding in any way whatsoever on public roads. You are not being encouraged to speed, and I'm not trying to give you ways of being able to do that and then get off scot-free. What this video is about is if you've been driving along and you get flashed, you're like, hang on, was that right? Was that what was posted? Is that technically correct? Am I in the right place? Is that camera right? You know, is the legal process correct? You know, if these are questions that have come into your mind, and also to see how maybe some other people, such as celebrities, have managed to get off speeding fines, that's what we're going to cover in this video. So we're going to look at legal loopholes. Now, also the other thing I will say is that I'm not a solicitor, I'm not qualified in law in any way whatsoever, so I cannot be giving you legal advice, so don't consider this legal advice. And if you find yourself in a situation where you think you might want to contest a fine or intent of prosecution or anything like that, then I would strongly urge you to talk to a professional legal person and get some solid advice on that. But what I am going to look at in this video is the sort of top level stuff based on the research that I've been able to do on how some people have managed to get off on certain loopholes that supposedly do exist and have been exploited for this purpose. The purpose of just justice, I guess. You know, I mean, if you haven't been caught fairly, then that's one thing. Also, there's some things, if they have not done correctly, if procedure has not been followed correctly, then that also could get you off a fine. In fact, many people have been able to get off just for that reason. And I'm going to get into all of that right after this.
A brown card guy.
So first of all, let's talk about how speed traps are supposed to work. Speed cameras, average speed zones, mobile speed bands, all of these sort of things. You know, they're not just randomly plonked on the curbside and switched on and off you go. They are supposed to follow very strict rules in the UK. Let me get into those rules. So number one, proper calibration and certification. Every one of these devices, you know, from a handheld radar gun to a fixed yellow Gatsa camera to the average speed cameras, all the rest of them, they must be type approved by the Home Office and regularly calibrated, usually once a year. They also need to have maintenance logs to prove that they have been tested and that they are functioning properly. If these certificates are out of date or missing, then anybody that they've caught, you know, that could be invalid. So that's an important thing to consider. We will come back on that with a little bit more detail. Number two, approved locations. So again, I know it feels like they just slap up the cameras or set them up wherever they feel like, but they must be placed, cameras and mobile cameras, they must be placed in approved pre-assessed locations. Typically where there's a history or proven history of accidents, speeding complaints, or risk to vulnerable road users like school children and elderly. Local authorities, often working with the police and the Department of Transport, create a camera site list that specifies where this enforcement can legally occur. And it is possible to see those. Just to satisfy my own curiosity, I was doing a search and I found a list for Hertfordshire, for example, and there was a list of every single camera and where it's placed and what have you. So if you just do a little bit of Googling, then yeah, you can find, or I guess you could go to your council and say, I want to see the list. So I'm guessing that it is, you know, Freedom of Information Act, you could probably get that. But they have to, it has to be decided beforehand. Right. Number three, clear visible signage. So, you know, hence all cameras in the UK, speed cameras must have yellow painting on the back of them or around them or whatever. They must have this yellow, bright yellow thing. And there must be camera ahead signs. They are part of the legal framework that they have to be there. Clearly visible speed limit signage is also absolutely essential. Advanced warning signs, the speed cameras themselves need to be there. And also something called repeater signs for limits below the national speed limit. So if there's a road where it's not a national speed limit, but they posted a lower limit there, then there needs to be repeater signs. So repeater signs, I'm guessing that, you know, they need to be, you know, spaced at certain intervals, and that's how they need to be. No sign, no enforceable speed limit, no valid fine. So it's something to keep in mind. Number 4, operating within the legal speed limits. I guess that sounds a bit obvious, but this covers, for example, temporary speed limits in, say, there's a roadwork or contraflow or something like that. If it hasn't been legally enacted via temporary traffic regulation order, then any camera enforcing it is on shaky ground. Literally, it could fall over. But I mean, it's like, you can't actually take that to court because it has to have had this temporary traffic regulation order in order to then bring that speed limit down to that temporary speed limit during the time that it's posted. So even if it's posted, unless it has that, it's not actually legal. So all of these things that I mentioned, if all of these things aren't correct and proper, then speeding offenses can and have been thrown out in court due to something as minor as a faded sign, a misplaced camera, or lapsed calibration date. And I will give you examples of that later on in this video as well. So let's get into the sort of main sort of loopholes, as they're called, that have been exploited in the real world to successfully beat speeding tickets, I guess. And I'm not saying, again, I'm not condoning speeding, and I'm not saying that you should rely on any of these, but I'm just trying to give you an example of how these things do exist, how this can happen, how injustice could possibly even happen. And I'll give you 5 loopholes that have been shown to work or have been known to work, and have even gotten off people like celebrities such as David Beckham, and I'll give you his example as well a little bit later on in this video. Number 1, missing or unclear signage. If you're driving in a 30 miles per hour zone and there's no visible signage, or the signs are blocked by trees or graffiti, roadwork barriers, bushes, anything like that, then the limit might not be legally enforceable. In the UK, the law requires repeater signs set at intervals for any limit that's under the national speed limit, as I just mentioned earlier. If those signs are missing or too far apart, you could also argue that you weren't reasonably informed of the speed restriction. So keep an eye on that. If you have a speeding ticket and you go, well, hang on, I don't remember seeing any signs on that road, then you might have a legal case. Number 2, calibration issues. And again, I discussed this. All the cameras have to be certified and calibrated. They are treated in court as precision instruments, but that means that they need to be regularly tested, logged, and Home Office type approved. If a camera hasn't been calibrated within the required period, usually 12 months, or the police can't provide evidence of certification, then the reading might be inadmissible in court. The loophole has worked in multiple cases, including where 1,800 tickets were cancelled, and I will tell you about that story as well just in a little bit. Number 3, the NIP timing. What NIP is a Notice of Intended Prosecution, NIP. And it's 14-day rule. So this is an important one. It's also quite a complex one. It's quite complicated. Fundamentally, on the basic aspect of it is that under UK law, police have exactly 14 days to send a notice of intended prosecution, an NIP, to the registered keeper's address for the car that's been caught speeding. This doesn't apply if you've been physically stopped by a cop. If you've been physically stopped by a cop and he's told you that we intend to prosecute you, then this doesn't apply. That means he's told you. So that's that. This is, for example, like, if you've been caught by a camera or whatever. If that letter that comes in the post, however, if it arrives to you on the 15th day or later, then that speeding charge becomes invalid regardless of whatever speed you might be doing. This is about when the NIP is received, not sent. And it only applies to the first NIP. So if they send you repeated ones, it's like, no, it's about the first one. From the moment the offense occurred, they have 14 days to tell you about that. It's a really tricky one because you have to prove. It's not up to the police, because the police can literally prove that, well, if they've posted it within a reasonable time that it should get to you by within 14 days, then they're in the clear. But of course, stuff happens. It could get lost on the post, or postal strike could happen, or whatever could happen, or bank holidays and stuff like that might happen. Then in that case, it might get to you on the 15th day or later, in which case, you then somehow have to prove that you got it late. So it's kind of tricky, but it has been done. The other thing to mention is the NIP is only required for certain specific things, so not for everything. So it's for speeding, it's for dangerous driving, it's for careless driving, driving without due care and attention, and for contravening traffic signals. So, you know, for example, if you jump a red light. So it's not for everything, it's for those specific things. And the other thing to remember also is that aside from the fact that it has to get to you within 14 days, also look at the date of when it was issued, because if the issue date on the notice of intended prosecution is more than 14 days after the offense, you can also reject it. So that's another thing to keep in mind. So number 4, driver identity unknown, section 172 loophole. Now again, this is also a very, very tricky one. It has been used, but it is quite tricky. If you're the registered keeper of the car and you receive the NIP, you are required to name the person who was driving the car at the time of the offense, right? So say there's a car, you got multiple people insured on it, it's part of your household, or maybe it's a company car, or whatever. So somebody else could have been driving it, but you are required to name who was driving it. So what if you don't know who was actually driving it? That's when it gets tricky. You could justifiably put that as a case, but the key is showing that you have made every reasonable effort to identify the driver. You've checked diaries, you've asked your passengers and everybody else in the household or the company, you've reviewed dash cam footage, for example, if you have it. So you've done everything to try and prove that you can't be sure who was driving it at the time, place that the offense occurred. However, be careful, because lying or making up names could lead to further charges of perverting the course of judgment, and that could make things a lot worse. I'll get into more detail a bit later on that one. And finally, number 5, this is an interesting one. Not public roads, wrong roads, private land, stuff like that. Not all roads are actually public highways, and of course traffic fines and stuff like that are applied on public highways. So if a speeding offense is recorded on private land, like an industrial estate, supermarket car park, or access to a private business, unless that land is adopted by the local authority, the road traffic acts and speed limits may not technically apply there. Take, for example, a racing circuit, right? A racing circuit is not a public highway, so you can drive as fast as you like there, right? And this has, in fact, been used by real-world cases where they managed to get off because of this, but it is quite complex, and there's more to it, and I'm going to get into that, and I'm going to get into those other real-world cases that I mentioned. But before I do that, if you're enjoying this video, make sure that you hit like, that you share it, that you leave a comment, and make sure that you're subscribing, of course, and support independent journalism, channels like mine. You can do that at Patreon, at Ko-fi, or right here on YouTube by taking a paid subscription on this channel. Or better still, I've got 3 books out at the moment. There they are behind me. The first one is an all-action thriller on the war on cars. It's just a fun ride. Go check it out. The second one is a collection of short stories that I wrote over 20 years. It involves sci-fi cars and the human condition. And the third one that I put out this year is a how-to guide, how to do what I do. So if you're interested to get into automotive content creation, then you need a copy of this. They're all available on Amazon and Kindle Unlimited. Go check them out. Go get a copy or more. If you like them, leave a review. If you don't like them, don't leave a review. Right, so as promised, there are some real examples of how people, in some of these cases, did manage to get off. Case 1, let's look at the time scale of the NIP, the Notice of Intended Prosecution. So there have been examples of drivers getting NIPs 16 days after the alleged offense, 2 days beyond the legal deadline. There was a court case, I think, Beckford versus DPP, heard in early 1997. The court ruled that the notice was invalid, so the speeding charge was dismissed. But sort of one of the more famous versions of this was none other than national footballing legend David Beckham. David Beckham was accused of driving a loaned Bentley at 59 miles per hour in a 40 miles per hour zone on the A40 in Paddington, London in early 2018. His lawyer, Nick Freeman, who apparently has the nickname Mr. Loophole. Is that true? I'm not familiar with him, but apparently. Anyway, he successfully argued that the Notice of Intended Prosecution, the NIP, was delivered 1 day outside the statutory 14-day window. Under UK law, the NIP must be served within 14 days, as I've said, for alleged offence, and any delay renders the case invalid. Now, this is a really tricky one in one sense, because the car wasn't his. So sometimes what happens is that you could argue that, well, I didn't get the notice, but if, for example, if your car is leased or something, and the registered, because what they do is they take the logbook, the current address on the logbook, whoever the registered keeper of the car is, that's who will get that notice. So even if you moved address and you've changed your address, but you haven't changed it on the logbook, and then you go to the police, well, I didn't get the notice, they're going to say, well, you put the wrong address on there, so that's not a get out. That is like, no, you have to keep everything up to date. But if, for example, leasing it and the lease company gets the thing, or in this case, Bentley would have got the thing, so somehow Bentley was able to demonstrate that, no, we didn't get it within the 14 days, we got it on the 15th day. So the advantage is a company like that, maybe they were having a logging system of posts coming in and stuff like that, so they were able to prove it. So the NIP itself was sent quite late, actually, 2nd of February. So again, it has to be within the 14 days of the date of the offence. So it was sent on 2nd February, it should have arrived by the 6th of February, but the court testimony and documents concluded that it actually arrived at Bentley on the 7th of February, making it 1 day late. And so the legal requirement was not met, and the judge basically said that Beckham could not be convicted. So there you go. So, and that has been done by other people as well. Case number 2 is about the camera not being calibrated. Now, this is a biggie. This is a biggie because this relates to, actually relates to Ireland. The N17 Clare Morris County Mayo, February 2023, I think it was 2023, 2024, something like that. 2024. So between 20th of December 2024 and 12th of February 2025, a static speed camera on the N17 near Clare Morris, County Mayo, I think it's County Mayo, yes, issued approximately 1,817 fixed charge notices to motorists for alleged speeding. Now, the camera was fully operational, but it was discovered to be uncertified. Its calibration certificate had actually expired. So technically, it wasn't legally authorized to issue these offenses. So upon identifying the issue on 12th of February, the authorities immediately certified that the camera, they certified the camera the next day. So only fines issued after 14th of February were then considered valid. Now, 800 notices had been paid and penalty points had already been applied. 122 notices were paid before the error was discovered, and there were 948 notices that had not yet been sorted out. Every one of the 1,871 notices were subsequently cancelled, with refunds issued and penalty points removed where necessary. So yeah, so that is a case of where there's a mass case of where a load of people got off simply because the camera had not been calibrated properly. So this is also, I don't know how they found out, but I guess, you know, I mean, if you're lucky enough to be in that situation where somebody challenges to see if that camera has been calibrated correctly or has any certification, then it's possible that you could be lucky enough to get off. But I would say that's an extreme good luck scenario, honestly. Yeah, good luck with that one, literally. Case number 3, inadequate signage, Coombs versus DPP on 2006. And this relates to a businessman, John Coombs from Wells, Somerset. He was caught speeding at 46 miles per hour in a 30 zone on the B3139 Bath Road at Horrington near Wells on 4th of July 2005. Now, he claimed that overgrown hedges completely obscured the 30 miles per hour sign, and no clear warning sign was visible as he passed from a 40 zone into the 30 zone. So he said, I was in a 40 zone, right? And then it dropped to 30, but there was no sign, so I didn't know that that had happened. So he was actually convicted in January 2006 at the Mendip Magistrates Court, and he was fined £250 plus legal costs. But in April, Bristol Crown Court still upheld the conviction, so he tried to counter it, appeal it, but they upheld the conviction by the majority, adding more legal costs. However, get this, 6 years later, April 2012, Coombs launched he was really a stickler with this one. He was not letting it go. April 2012, Coombs launched a High Court test case, arguing that the local authority failed in its duty to maintain legally adequate signage in breach of the Road Traffic Regulation Act 1984, Section 85. Judges ruled that the road was not adequately signed because the obscure sign failed to give drivers reasonable warning of the speed limit change, even though an opposing sign on the other side did exist. But it was accepted that most drivers would not see that in time to slow safely. And Coombs' conviction was then quashed with his legal costs reimbursed from public funds. Wow. Good luck. He was persistent, he stuck with it, and he won. And he set a precedent, he set a test case that can also now help other people. It's a legal landmark case. So this is the one to remember. If you think that, no, the sign was obscured, this is not fair, I could not see the sign, so therefore I cannot be prosecuted. Case number 4, the unknown driver, Section 172 defense. It's actually a surprisingly common legal defense, apparently, and it has been successfully used many times. The UK, we can't find any publicly named Section 172 success story cases, mostly I think because, with the Section 172, you can't name anybody, so they're private, etc., etc. But apparently there's countless anonymized cases demonstrating that keepers can escape, by keepers I mean registered keepers of cars, can escape prosecution if they genuinely don't know who was driving the car and can show that they made every reasonable effort to find out. So here's a scenario that, let's say you are the registered keeper of a car and an NIP lands on your doormat within the allotted time, and the thing that they ask you is who was driving the car, and you genuinely don't know. And it's got to be a case of you genuinely don't know. I mean, don't try and cheat the system, don't try and lie, but if you genuinely don't know, but then you have to prove it, right? It could have been your partner, your family members, or people in your company, who knows? If you've got no dash cam, no diary, no receipts, no evidence of who was driving the car at the time, and the camera hasn't taken a picture, because don't forget the camera might have taken a picture, but I think normally these days they just capture the number plate. Well, under Section 172 of the Road Traffic Act 1988, you have a legal obligation to name the driver unless you can prove that you've taken all reasonable steps to find out, and you still couldn't identify who it was. And this has worked in court. In 2012, there was a case, Lynn's case, I believe, that confirmed that registered keepers aren't presumed to always know who is driving. So this set a precedent saying that just because you're the registered keeper doesn't mean that you must know who was driving at that particular moment that fine or offense occurred. What counts as reasonable steps? Asking everyone who had access to the car, checking diaries, phone records and texts, reviewing dash cam or CCTV footage. So don't forget, this is the other thing, CCTV footage could be used. So police could use CCTV footage in the area to go, oh, okay, yeah, we can see who's driving the car. So again, don't lie. Don't lie. And so, because you'll be found out. And of course, like I said, you could maybe ask for the image to see if they've got a bigger version of the image. You could say, look, I don't know who was driving it. Can you send me the full image? You could do that. Motoring solicitors regularly defend drivers using this argument. In fact, several firms have reported success rates of over 90%, provided the driver submits solid evidence of their inability to ascertain who was actually driving the car at the time. But, and it's a massive but, as you can guess, like I said, if you make up a name or you blame someone falsely, you could be jailed for perverting the course of justice, I should say. So don't even think about doing that. Case 5, wrong road, private road, what does or does not constitute as a public highway? And this is a very tricky one, because even a private one could actually be subject to the rules, and in some cases might not be. Under UK law, speed limits and traffic offences only apply on public highways or roads where the public has lawful access under Road Traffic Regulation Act 1984, Section 142. If the location is private, say a business park or a retail access lane or an unadopted estate road, the offence may be invalid. It is on the Crown to prove that the road was actually public. Now, even if it is a private road, it could still be subject to these things. So don't just assume it's a private road, so it's not subject. There was a road on the Isle of Wight, a privately owned road in Ryde was not regarded as a road under the 1984 Act, despite the fact that local pedestrians and residents were actually using it. And so the council said there should not be a traffic regulation order applied to that road because it's somebody's road. However, the High Court overturned that ruling based on the fact that under Section 142, the public did have habitual and tolerated access to the road even as so-called trespassers. In that particular case, a public tolerance counts as access, so therefore it was a public road. So you have to be careful. So just so like, okay, this road is owned privately, so therefore the speed limit doesn't apply. But if the public is using it and if the local authorities are using it, then even if it's private, it could still apply. So don't just assume anything. However, having said that, there are multiple unreported cases where motorists have successfully appealed speeding fines in things even like supermarket car parks and stuff like that, and industrial estates, where they've said, well, the road wasn't adopted by the local authority, no traffic regulation order existed, and so therefore they cannot be fined in that area. Right, so there you go. That's covered the loopholes and real world examples of how people have got off those things. But can we just be real for a moment? Yes, drivers have managed to dodge speeding tickets through these technicalities, but just because you can doesn't mean that you should. You should use your common sense and go, right, well, this is just not a good idea. Just this morning, there was a guy, I was coming back from Willesden area to northwest London, and this guy in a Mercedes was just cutting in and out, dashing in and out, making these rash moves. And the weird thing was, like, I followed him for like 2 blocks, and I was just sticking to normal speed and stuff like that, and I could still see him. He wasn't making much progress because he was just driving so erratically, but just so recklessly and fast. And in fact, he almost crashed because we got onto a single lane carriageway, and he pulled out to overtake just before the crest of a hill and nearly crashed into a lorry coming the other way, and then had to pull back in again. But then he still went for the overtake afterwards, and he went for it. I mean, that's just stupid, and the morning rush hour thing, doing stuff like that, there's just no condoning that. That guy should get his license taken off him and his car confiscated, quite simply. Unfortunately, I don't have his number, the number plate or anything like that. I was too busy driving and trying to stay safe. Frankly, when I see people like that, I actually back off. I'm like, you know what, go have your accident somewhere else. I'm just going to stay over here. You're a nutter and you're dangerous. But anyway, so not condoning any of this stuff, right? And you need to remember, right? People do get killed, 1,600 people in 2023. And remember, speeding, if you hit the pedestrian at 30 miles an hour, they have an 80% chance of surviving. At 40, it drops to just 20%. From 80 to 20%, just from 10 miles per hour. It's incredible. And 50 plus, you probably killed them. So be careful. Be very, very careful. So once again, to reiterate, this video isn't about helping anyone breaking the law or finding loopholes so that they can go out and speed. This is not what it's about. It's just pointing out that the law must also be enforced fairly and transparently, because safety and justice go hand in hand. And when authorities cut corners, people lose trust. And that's also a dangerous thing. So just be aware of your rights, but also your privileges as a driver and the responsibilities as a driver. So as long as you're aware of all of that, then you should be safe out there. But if you find yourself maybe unfairly or unjustifiably penalized in any way, then you maybe will have some rights to recourse. I will also, what I'll do is I'll put this all in a PDF. So I'll put like the main things on the PDFs, and I'll put them on my website on browncarguy.com, the related article to this video. So if you go there and register, and then I'll send you that PDF so that you just have a checklist, for example. So anyway, love to hear your comments on this. Look forward to hearing your feedback in the comments below. Make sure, like I said, you've hit like, share, and subscribe, and I'll catch you all in the next video.